Welcome, everyone, to this panel on legal strategies for protecting wildlife. My name is Reddy, and I direct the Animal Law Program at the Center for Animal Law Studies at Lewis and Clark Law School. I'm looking forward to this exploration and discussion on effective litigation, legislative, and regulatory strategies for safeguarding wildlife. And with that said, it's my pleasure to be able to introduce my co-panelists. Speaking first is Katie Kraska, a former lobbyist who spent 7 years leading federal initiatives at the ASPCA with a particular focus on equine welfare. Currently, Ms. Kraska is pursuing a PhD at Harvard with a focus on food systems, environmental and agricultural technology and policy, and innovative approaches to overcoming socio-political gridlock. Presenting next is Eric Glitzenstein, Director of Litigation at the Center for Biological Diversity, which is dedicated to preventing human-caused extinctions and protecting life on Earth. Mr. Glitzenstein oversees and coordinates the center's litigation brought under the Endangered Species Act, the National Environmental Policy Act, the Migratory Bird Treaty Act, and Clean Water Act, among numerous other statutes. Please join me in welcoming them.
I'm Eric, by the way. Okay, so what I'm going to talk about, a lot to talk about in wildlife issues, but I'm going to focus on something which is kind of a burning issue right now for unfortunate reasons that I'll get into, which is that there's a case involving the National Environmental Policy Act in the US Supreme Court, which is most people, I think, probably realizes these days rarely a good thing for anything that we collectively care about. But anyway, it is what it is. So I'm going to just do a bit of an overview of NEPA, an important wildlife protection statute, and then talk about the Supreme Court case, and then be happy to field any questions that people may have. So a bit of an introduction, and there was a great panel discussion on NEPA yesterday. I think, as people know, it was a great intro to the statute. So I'll go over a little bit of that and then lead up into where we are right now. So NEPA was signed into law by President Nixon. Show you how far we've come. Never would be signed into law today. After a unanimous vote in the Senate and a nearly unanimous vote in the House, and it declared a national policy to promote environmental protection for future generations. And its purposes, among other things, are to encourage productive and enjoyable harmony between humans and the environment. So it had these very laudatory objectives. Fundamental to the statute is what I'm sure many people are familiar with, which is the obligation to prepare an environmental impact statement. And that provides, and this is actually based on a fairly recent amendment to NEPA, which occurred within the last couple of years. And this is what the current language is. It says that to the fullest extent possible, all agencies of the federal government shall include in every recommendation for proposals for legislation and other major federal actions significantly affecting the quality of the human environment, among other things, reasonably foreseeable environmental effects of the proposed action. And I'll get back to that in a minute, because that language is central to the Supreme Court case going on right now. Any reasonably foreseeable adverse effects which cannot be avoided, and then, among other things, a reasonable range of alternatives to the proposed action. Critical aspect of NEPA. If you look at NEPA on its face, this would not be self-explanatory, but as construed by the Supreme Court, NEPA is entirely procedural. Supreme Court, in a series of cases, and I've quoted some of the language here from a case called Stryker's Bay, while establishing a significant substantive goal, imposes upon agencies duties that are essentially procedural. So basically what the Supreme Court has said is that so long as you adequately consider impacts on the environment, which include, of course, wildlife impacts, but a range of impacts, as long as the agency considers them, it can then do whatever it wants. It can make as irrational a decision it wants. It may be limited by other things, its own substantive mandate, the arbitrary and capricious standard in the Administrative Procedure Act, but NEPA itself does not tell an agency what it has to do. It simply says what it has to consider. So this is a very critical element of NEPA as construed by the Supreme Court. There are multiple levels of NEPA review, and people focus on the ES requirement, but that, as I just mentioned, only applies to major federal actions significantly affecting the quality of the environment. And mainly through regulatory construction and implementation, agencies have figured out various ways of avoiding getting to the EIS requirement. One of the ones that people who have litigated in this area may know about is called an environmental assessment, which is sort of like a rough cut environmental impact statement, more cursory, designed to determine whether or not an agency's action will be significant enough to warrant an EIS. But then on top of that, this isn't increasingly happening, and I think this is actually was alluded to yesterday. Agencies have figured out ways of avoiding NEPA obligations to some extent entirely through what are called categorical exclusions. What is that? That is basically a situation where an agency by rule says, here's an entire range of actions that we've decided will never be significant enough to warrant an EIS or even an environmental assessment. And that has become, for sort of obvious bureaucratic reasons, increasingly popular as a way of complying with or avoiding compliance with NEPA, depending on how you look at it. Now, NEPA has been an extremely important, perhaps one of the most important statutes for actually addressing wildlife impacts through federal agency actions. And I'm just going to mention a couple of examples just so people know the sorts of things we're talking about. And people, especially in this region, may know about what's been a longstanding controversy, the Makah whale, the tribe's desire to hunt whales off the coast of Washington, a very controversial effort that our firm was involved in a series of cases, and actually were able, largely through NEPA, not entirely, to basically stop the Makah whale hunt for about 25 years. Unfortunately, it's something which continues to be in the works, and only recently the Biden administration approved, and we still have a couple of procedural steps to prove the resumption of Makah whaling after doing a full environmental impact statement. But originally we won a case, and it highlighted the timing aspect of NEPA, where the Makah tribe basically had an agreement with the National Marine Fisheries Service to support Makah hunting before the International Whaling Commission. And only after the agreement was entered into did they do NEPA compliance. And the Ninth Circuit said, no, that's not the way it's supposed to work. If you're going to inform agency decision-making, you have to do your NEPA compliance before you enter into the agency commitment to support it. So that was just an example. And the impact that was of concern for people who may have followed this, and there's a great book out about this, was the impact on the local whale population. The argument was, well, we've got whales going up and down, gray whales going up and down the coast, but the evidence showed that there was a very small but localized population of gray whales, families of whales who were basically just hanging around closer to shore, and the issue was whether or not it would impact those whales. And that resulted in a follow-up case where the agency came back and this time did a new analysis, but before they entered into any formal agreement. But this time they concluded again that an EIS was not even necessary because it was not sufficiently significant, because it wasn't going to affect this overall major whale population. And the Ninth Circuit, in an important NEPA ruling, said, no, the localized impacts could be sufficient for significance. And it's also sufficiently controversial because the scientists who are experts on this species have come to a conclusion that this local population of whales could be significantly affected. So the Ninth Circuit, about 20 years ago, said you have to do an EIS. We were hoping, from our standpoint, that would be the end of this. And it was a difficult case for us, I should say. Talk to people about that more independently. We usually like to be on the same side as the Native American groups and tribes. And this was one where, unfortunately, we were on the other side. And we were supporting, non-lethal ways, ecotourism, of benefiting from the whale population. Unfortunately, the tribe continued, or at least some members, it was actually even controversial within the tribe, continued to insist on pursuing the hunt. So actually, this thing has come back into the fore, and you'll probably see more about that over the coming months and years. An important Supreme Court decision occurred, and it just also highlighted the wildlife-related impacts of and importance of NEPA, as a case called Winter versus NRDC. And as people may know about that case, and this involves a huge issue of the impacts of sonar on marine mammals, and in particular, the Navy's use of various sonar systems were disrupting, and I know there was just a panel, of course, on whale communication disrupting the ability of whales and other marine animals to communicate. In that case, an EIS was prepared, and the question was, what was the remedy? And a court affirmed by the Ninth Circuit had issued a far-reaching injunction against the military activities, and the Supreme Court, decision issued, authored by Chief Justice Roberts, didn't say anything about the merits of NEPA, but basically said at the end of the day, even if you have a NEPA violation, that doesn't mean you have to enjoin the agency action. You can still basically just make them do NEPA compliance, but you have to weigh all the factors, the equitable factors, and national security factors outweighed what the court said was important wildlife considerations, but not as important as national security. And if you have a decision which is those kind of like obvious judicial activism, it's like, they don't really explain why. They just say, well, it's obvious that national security in this situation is more important. But anyway, an important remedy decision in terms of the ability of, even if you have a NEPA violation, are you going to issue a remedy that's going to be meaningful and enforce NEPA's procedural component? And that brings us, with a very quick background, to where we are with the current Supreme Court case, a case called Seven County Infrastructure in the Supreme Court versus Eagle County. And a brief description of the project helps to highlight why we are currently where we are. It's a project that connects two termini in the United Basin to the National Rail Network. So it's a new railroad that's going to be built for the first time ever, 88-mile railroad project. And it connects something called the Uinta Basin, which contains extensive deposits of various minerals, but particularly oil. Trucking is now the only route for getting that oil out of the basin. So to increase substantially the amount of oil that can be removed from the basin, this is a railroad system designed to greatly facilitate the transport of oil from that basin in Utah to East Coast refineries. And there's no doubt, and the explicit objective of the purpose is to greatly increase the transport of crude oil produced in the basin. This gives you a bit of an idea of what the project entails and what it looks like. It's got that red line is where the project will actually be built, taking oil from that area in Utah and to an existing rail line that would then transport the oil down to the coast, East Coast. This is what the basin sort of looks like. It's a largely natural area right now. There is, as I mentioned, some oil production going on, but for the most part, it's one of the most unblemished areas in the state of Utah and of relevance to us here today. A particularly important and significant wildlife habitat for a whole range of species. And some of the species that will be impacted by the project, should it go forward, are the greater sage grouse. People may be familiar with that species, which is being increasingly imperiled by habitat loss and destruction, among other things. The bighorn sheep, a really important habitat for bighorn sheep in the midst of where this project would increase oil production. And then up and down the line, and impacts would be felt not only in the Uinta Basin, but as the railway moves forward and increases oil production, increases the risks of fires, oil spills, et cetera, along the Colorado River, a variety of fish species, including the razor sucker and other imperiled species would be adversely affected. This is just a handful of the wildlife species that would be harmed. So this case went to the DC Circuit. It was one of these direct review cases. And it was a review of an agency decision. An agency is called the Surface Transportation Board, whose sole mission is to basically review applications to build railroad projects. Actually didn't even know it existed before this case, but it's one of those agencies that has this kind of unique responsibility. And it had decided ultimately, after considering all the environmental effects, but also the purported benefits, which were largely to increase oil production and jobs associated with increased oil production, that those outweighed the environmental impacts. And challenges to that were brought by a coalition of environmental groups led by the Center for Biological Diversity had one case, and another case was brought by a county, Eagle County, Colorado, because they will be directly affected when there's a significant increase of the amount of oil that is moved along these rail lines down to East Coast refineries. Now, case was won in the DC Circuit on a variety of grounds, only some of which are relevant to the Supreme Court case. Of relevance, the Supreme Court held that the EIS, which was prepared, was improperly narrow because it ignored both the upstream effects and the downstream effects. What does that mean? They basically only looked very narrowly at the impacts in the direct footprint of the railroad. But even though the mission of the project was to increase oil production in the Uinta Valley significantly, and they looked at the economic benefits associated with that, they ignored all the wildlife and other impacts associated with that. Downstream, which has kind of been divided into downline, which means further down the train line, they had ignored impacts on increasing the chances of fires and oil spills, and ignored the impacts on the Gulf communities that would receive the oil, and particularly air pollution, as people may know, huge environmental justice issue already in those areas, massive increase in the burning of oils in some of those refineries, and the DC Circuit said that is a violation of NEPA. You didn't take, in NEPA language, a hard look at either the upstream or these downstream impacts, and therefore found that that was a significant NEPA violation. Now, I have to get a little bit into the underlying analysis of some Supreme Court precedent because it comes critical to why the case is in the US Supreme Court now. There's an important case called Department of Transportation versus Public Citizen, Supreme Court case, without going into the gory details of that case, basically held that if an agency doesn't have discretion to take certain impacts into consideration, it doesn't have to do NEPA analysis on those impacts, which makes sense if NEPA is entirely procedural and its entire purpose is to inform agency decision-making. Then if the agency, as a result of its own statutory mandate, cannot consider these impacts, then what's the point of having to do NEPA review on them? And in that case, the Supreme Court said the decision at issue was ultimately a presidential decision. It involved allowing trucking across the US-Mexico border. The agency at issue had no ability to influence that presidential decision. So they said in that case, you didn't need to do NEPA review. Here, the DC Circuit said, well, that case doesn't really come into play because everybody concedes that under the statute that the board operates under, it can consider these impacts. And that is a critical concession which continues to apply as the case is moving through. So we were all very happy. We won this case in the DC Circuit. One hopes that that's the end of it and this really bad project would go away. As it turned out, that's not what happened. The proponents of the project filed a petition in the US Supreme Court, and they argued their principal argument, and this is, people may know, this is one of the ways in which people can try to get review in the Supreme Court, is arguing there's a split in the circuits. What does that mean? It means that the various courts of appeals have reached differing conclusions about a critically important area of the law. And here their principal argument was there was a disagreement about the meaning of public citizen, the case I just mentioned. Everybody agrees that it means that if an agency has no discretion to take an impact into consideration, that's the end of it. They don't have to do NEPA review. But they tried to take it one step further. They say that what public citizen really means that an agency, in their view, has no ability to do NEPA review on anything outside its direct regulatory jurisdiction. It cannot consider any impacts outside of the immediate thing that that agency has authority and jurisdiction over. We can get back into a moment about how that would literally eviscerate NEPA, because as you can imagine, almost no agencies have this mandate to consider all kinds of impacts, particularly indirect effects, which will occur after the agency does the immediate thing that it's going to do. But that was their explicit focus in the case, was on this purported circuit split. Now, the federal government, thankfully, although unsuccessfully, filed that actually, even though they're the ones we sued, they filed an opposition to the cert petition. And they said, no, this circuit split doesn't really exist. It's not that significant a case. The petitioners won a host of other grounds. There's no reason to take this case. And of course, we filed an opposition, as did the county, and we thought we had a pretty good chance because we didn't think this was an issue the court was going to really get that excited about. Nonetheless, the court did, in fact, take the case. Granted cert on the following question. And to be honest with you, I could read the question to you. We still don't know exactly what it means. And the question is, as you can see, whether NEPA, quote, requires an agency to study environmental impacts beyond the proximate effects of the action over which the agency has regulatory authority. So that is the question which is currently between the Supreme Court. On its face, it has extremely significant impacts for wildlife and the ability of NEPA to be used effectively to address wildlife impacts. because most agencies, as I just mentioned, do not have direct regulatory authority over much beyond the immediate thing that they're required to look at. And just to give one example, migratory birds, huge impact that many agency actions have on migratory birds. We're actually right now suing, those of you who are Elon Musk fans, I'm sorry, but we're suing SpaceX over their Boca Chica facility in Texas. Because as people may have seen, it's actually decimating the wildlife and refuges down where those huge rockets are going off, as well as destroying the local community. And it's basically a project that's been approved by the federal administration, FAA, Federal Aviation Administration. Well, they don't have any direct jurisdiction over migratory birds. So under this approach, they would basically ignore any impacts on the surrounding refuges. And we've got evidence that basically nests of migratory birds have been directly destroyed by the blast-offs whenever they occur. So as you can see, I think this would be a devastating kind of approach if it were to be adopted by the court. Now, their merits brief, interestingly enough, winds up taking a radically different approach than their cert petition, which is not usually supposed to be what happens when you're in the Supreme Court. But in any event, they've backed off somewhat on the direct regulatory authority point, in part because it's explicit language in NEPA, we assume, that kind of undercuts that. Because instead of saying you can just look at what's immediately within your authority, it actually requires agencies to reach out and consult with other agencies that have direct jurisdiction or authority. So how could that be? And still, it clearly implies that you have to look at things outside your direct frame of reference, and here's how you're supposed to do it. Instead, what they've come around to is a much different position, a shift to an emphasis on what I've summarized here as a strict application of proximate causation under tort law. And if you read their brief, it's really quite fascinating. So they've picked up on little bits and pieces of prior Supreme Court cases and have said the new test for NEPA should be whether the agency would be liable for these actions under tort law. And their argument is that, well, the Supreme Court's alluded to proximate causation in some prior cases, and the only way to really make that meaningful is to basically say that we have to have this strict notion of proximate causation. Now, how many of you have taken torts? Okay, how many of you think you can explain very coherently and simply to somebody what proximate causation in tort law means? Exactly. And if you read their brief, they seem to have no real idea either, except they want to use it to basically go after NEPA's coverage. But their whole concept seems to be we have to narrow NEPA as much as possible, and we're going to try to use this tort law liability concept as much as we can. And really, the entire brief is really just basically a tirade against NEPA. It is just one argument after the other in so many words that they just think the statute is really stupid and nobody should have to comply with it on the way to doing the things that they want to do, but they have to basically dress it up at least with some legal argument, and that's kind of the one that they've come upon. So other briefs, and this will kind of leave us where we are right now. The government filed a brief, which is kind of an odd brief. So even though they opposed cert in the first place, they filed the merits brief, which actually wound up agreeing with us on some issues, including that there should not be this strict tort liability notion. They agree that that's not really sensible or workable in the NEPA context. They reject this direct regulatory authority test, but then they basically, not surprisingly, it's the government say, really the test should be whatever the agency thinks the range of impact should be that we want to consider. So a context-specific test that is really ultimately very deferential to the agencies, which is not all that surprising. That's frequently what they want, but kind of leaves people scratching their heads as to what the ultimate test would be. We actually just filed our brief, as did the county, on Friday. And so people can actually read that online if you want to go to the US Supreme Court website and get the briefs. And among other arguments that we make are this direct regulatory test, which they appear to have backed away from, never made any sense. And neither does their tort law proximate cause test, which really has no relevance to the NEPA context. NEPA is not about assigning liability. It's about agencies informing themselves about wildlife and other impacts. And so we make that argument, and then we ultimately argue, look, this is a policy dispute. And if you as the Supreme Court, as you always say, shouldn't be substituting your policy judgment for that of Congress, which, by the way, just amended NEPA a short while ago to incorporate what we think is the right standard that's been in the law for years, which is this reasonable foreseeability standard. Is it reasonable foreseeable
Do you have enough information to engage in serious analysis? In this case, we think the answer is clearly yes. If you know for a fact that the purpose of your project is to increase vastly oil production in this area, then you should be able to analyze what the wildlife-related impacts and other impacts would be. If you know you're shipping that oil and the purpose is to Gulf communities already hard hit by pollution from exactly these kinds of activities, you should be able to do an analysis. And by the way, they've predicted this project will result in at least 1% or more of entire world, US greenhouse gas emissions if and when it goes forward. So we're talking about a significant project from a whole different ways of looking at it. So those briefs have just been filed. The oral argument was just scheduled for December 10th, and that's where we stand right now. The petitioners will have a reply brief that they can file. Amicus briefs, as you might imagine, have been filed on both sides. The usual suspects supported the petitioners. Pretty much every industry group under the sun have filed a brief basically saying, yeah, we agree with those guys. NEPA's a really bad idea. It's prevented us from doing this, that, and the other thing. And on our side, we've got amicus briefs coming from a range of interests, including prior officials who've worked in the government who say, oh, we can work with NEPA and it's helpful to us. Prior people who have administered this statute specifically. Howard University's law clinic is filing a brief reflecting environmental justice and tribal interests. So I think all those interests will be adequately brought before the court. And at the end of the day, though, as you know, we have the court that we have, and that is what it is. So I'll be happy to answer any more questions later on, but that's just at least a thumbnail sketch of where we are, NEPA generally, and also where this Supreme Court case stands. Thanks.
Not really sure how I'm going to follow that up. The imposter syndrome is very real this morning, being on the stage with someone who just got a Lifetime Achievement Award. So big congratulations again. So today I'm going to be talking to you about wild horses and burros. Please excuse the myriad of puns that I'll be making throughout the presentation. You can see the first one is already up here. I'm currently in law school. This is the only way I know how to have fun. So this is what we're doing. So the reason that there's an elephant up on the screen is because rather than a horse, I'm going to be talking about wild horses and burros in a political context. And since we're going to be talking about burros, Democratic donkeys, I figured I would give a shout out to the Republican elephants when we get started. So my name is Katie Kraska. I'm currently a 2L at Harvard Law School. Prior to joining law school, I was director of federal legislation for the ASPCA, and I worked as a lobbyist in the trenches of Congress and regulatory agencies for about 6 years. And I want to start the conversation scaling out a bit and taking a big picture look at the political context that animal issues are working within. I think it's really easy for us to think that animal issues are the only thing that matter to folks on the Hill because they matter so much to us. But if you put yourself in the shoes of the folks that are working up there, it doesn't matter the issue like labor, taxes, housing, the environment, retirement, abortion, everything has to go through this same funnel, right? So it's worth taking that seriously and giving that a lot of consideration. So we're going to talk about political context first. The general landscape, and then we'll walk through strategies. I did all these fun animations and now I'm regretting it. So we'll walk through strategies that work in the system and how to pick them based on characteristics of the issue that you're working with in particular, what we can leverage to make progress, what constituencies we should be concerned with, and how we angle ourselves to make the positive change for animals in a very difficult and complex federal sphere. And then we're going to switch gears a little bit and talk more granularly about wild horses and burros. What does this issue look like on the ground? Who's involved? Who are the players? We'll get into the science of range management a little bit, and then cross-reference this information with the strategies we discussed at the beginning, and think through pros and cons of different approaches. And then finally, we will circle back around to talking through strategies, and then we'll consider some of the strategies in the real world and how this stuff is playing out on the ground. So the big circle here is representing the total number of bills that have been introduced in Congress this year, or maybe just this Congress. And then this tiny little dot right here, this represents the total number of bills that have been passed. I actually think that this is an exaggeration of how big that dot should be, because we're talking about over 5,000 bills that have been introduced in the 118th Congress. And as of 2023, so it's a little unfair, only 27 had been signed into law. But even if you double that number, it's still a drop in the bucket. The point is that the odds are like very, very heavily stacked against us, and they're working on a ton of other stuff that they have to get done within a very finite time frame. So the Senate is in for 131 days out of the entire year, and the House was scheduled to be in for 112. In session, as everyone knows, means that members are around to vote. When they are out of session, they go back to their district and they're not doing work. And in the midst of this, they have to fund the government. They have to pass the National Defense Authorization Act, the Farm Bill, other reauthorizations that are going on. They have to do nominations. And the biggest thing that's working against animal issues, and really any issue on the Hill, is the clock, because Congresses last for 2 years. There's a ton of stuff going on every month, and then they go out of session pretty frequently. So time is the biggest enemy, and especially for animal issues, even though congressional offices tell me that this is like the top 3 issue that they hear about, even after like that entire list that we talked about before, it's always one of the top. But the opposition to animal welfare issues, they don't need to oppose them necessarily. They just have to wait. The magnetic pull of the status quo is extremely, extremely strong in Congress, and this is by design. So that's what we're stacked up against. So with all this sort of scene setting in mind, I want to consider various strategies for getting bills across the finish line. And in my experience, there are 2 main ways to get things through. The first is flying under the radar. Don't talk about the issue. Don't bring it up with the broader constituency. Don't make it a thing. Or get on the party platform and make it a big, big thing and hope that you can ride through on the coattails of one of the parties. There are pros and cons to each of these strategies, as I think are pretty apparent. Flying under the radar requires being like quite bipartisan. It can't be super contentious. It can't be things that people are going to notice too much. They have to get slipped in without drawing too much attention to the issue. A lot of animal issues can fit this bill, but it makes them super, super easy to ignore if there's a lot of other stuff going on, because there's not much attention being paid to these issues in the broader public. The party platform is great when that party is in control, right? Like you're making that issue relevant to what the party cares about, they're talking about it and they're pushing it through. But when that party is not in control, there's a lot of backsliding, there's a lot of threats. And it can be a really scary time for animals if you hitch your wagon one way or the other. So before deciding on a legislative strategy, there are some key considerations to make about the nature of the problem, how it's best solved, who are the players that might help or hinder, and how quickly we need to get it done. So is this something that can be fixed by working with an agency? Is this something that needs legislation? Is it something that can be funded? Do we want like a sweeping pie in the sky legislative fix, or is a small, more technical fix that's maybe more supportable going to be sufficient, at least in the short term? How do people care about the issue? Are industries at stake? Do states care? And then finally, how urgent is the need? And this is a really difficult question, I think, to answer, because it feels like all of these issues are urgent. But it's important to remember that everyone lobbying Congress thinks that their issue is the most important issue. And this is why strategy considerations are really important to consider at the outset when you're planning making moves. So all of these factors are going to weigh on whatever strategy we take. Okay, so now switching gears to something that's maybe more fun for this crowd to talk about. Wild horses and burros roam federal lands in 10 states across the West. As you can see from this map, Nevada has the lion's share, but they're spread out across a lot of different territories and HMAs. HMAs are herd management areas, which are managed by the Bureau of Land Management. Territories are managed by the U.S. Forest Service, and horses live on both of those areas. And they share those public lands with a lot of other wildlife species. They share them sometimes with humans, and then also lots and lots of livestock, as you can imagine. These are often multiple use lands. And I put the population numbers up here just to give you all a sense of where we're at. I'm going to show some graphs in a minute, but the on-range population is the horses that are like roaming free in the West. The off-range population are the horses that have been removed by one of those agencies and put into either corral facilities or pastures. Corral facilities are meant to be short-term, pastures are meant to be long-term. It's questionable how short-term those corral facilities are becoming. And just to give you a sense about like population ecology, there's not a lot of natural predation that occurs in most of these places. There's just not a lot of natural predators that are like overlapping with wild horses. And their populations grow pretty quickly, and the federal agencies are mandated by law to manage them. So why do people get so excited about this issue? At least in Congress, and of course, none of these graphs are mine. I just wanted to give you a sense of like the reports that are coming out of the government. The left is, is this on the left on your screen? Yeah. So the left graph is a little outdated, but it shows how the on-range population was growing over time, over like the last quite many years, without a lot of active management on the BLM's part. And it also, on the right side of the screen, shows a corresponding increase in the amount of funding that's going towards this program. So these are from CRS reports. And basically the dynamic that's happened over time is BLM has chosen to remove some horses from the range, and then they put them in off-range holding facilities, and then the number of horses in off-range holding facilities grow, right? And then the horses on the range continue to grow because they're taking the, cream off the top and putting them over here. Sorry. So you have population growth like on range and off range simultaneously. And the best way to slow this down is with fertility control. These options have been available since like the 80s and 90s. They're proven safe and humane. There's a variety of reasons why BLM has chosen not to go down the fertility control path. It's been very frustrating for advocates because these technologies have been available for so long, and they would cut costs for the agency because then they wouldn't have to put horses in off-range holding, which is taking up the lion's share of the budget. I think part of it is that horses are really hard to access. I think anyone who's been to the West knows that these landscapes are really, really vast. And in order to implement fertility control, you have to be able to dart the horse with a dart gun, or at least that's one strategy. Or you can gather and then treat the horses and then let them go after that. So it is a really difficult process. It's time consuming. And because so much of the BLM's budget is taken up by off-range holding already, it doesn't give them a lot of wiggle room to work with the other part of their budget. So really like they need more money for management because they've dug themselves really deep into this fiscal hole. Culturally, they're also really used to doing it a certain way, right? Like agencies get very set in their ways. They're very bureaucratic. It's very hard to get them to accept new technologies, to move in new directions. I mean, this is true even with like email or IT, think about like on-range management for horses. So it applies to everything. And then a lot of the technology that's available also requires boosting their immunocontraceptive vaccines, which require a booster like after they're first vaccinated and then again after a certain time period. Newer technologies have come online that allows that time span to pass like a lot more readily, but the reality is you have to continue treating the horses. So it's difficult for the agency. So these are all pretty complex reasons why they've avoided using these technologies, but one major final reason is the political gridlock that has congealed around this issue. I don't know if any of you have ever been involved in the wild horse issue, but there's a lot of really, really passionate people coming from every dimension. Public lands just in and of themselves attract a hodgepodge of interests that are all pushing in different directions. The livestock and ranching industry obviously is pushing back on like any government measure to better animal welfare, especially protecting an animal that competes with livestock on rangelands. Traditionally, these groups have been pushing for sale to slaughter or other lethal methods of population control. There's also been a lot of dissonance amongst advocates about what the best and most humane strategy is for managing wild horses. There's not a lot of agreement in different spaces about like what is the best approach. And that makes things it makes things difficult or easy for lawmakers depending on how you see it. It makes us very, very easy to ignore because we don't really know what we want. There's a lot of different pushing from different directions. So they just throw their hands up and they're like, okay, we're not going to make anyone happy. So we'll just focus on another issue. And governments are obviously like super concerned about this because of the rising costs and because of the lack of end in sight for that rising cost, that there's no real cap. Like on-range populations are going to continue to grow and off-range populations are going to continue to grow unless there's some sort of intervention. And then there's a bunch of other groups involved that you can see up here that are all asking for different things from how to manage public lands. And I should just note that like any management strategy that's chosen is going to have consequences for welfare. It doesn't matter if you choose to do nothing, like that's going to have consequences for the welfare of wildlife, also for the welfare of horses. I think we all know that climate change is a thing. The West is changing. BLM has been doing emergency gathers to take horses off of areas that are really, really resource depleted when they're not looking good. So there are a lot of issues that can arise from not doing management. There are also a ton of issues that can arise from doing management because helicopter gathers, which is the predominant choice, is super stressful for the horses and it can be really dangerous. And then keeping them off range for their entire lives, depending on the facility, can be questionable since they're oftentimes like in these corral facilities that look essentially like feedlots. So this is all set against the legal landscape, and I'm not going to go into all of these different laws. I just want to note that the agencies that are managing horses do have to follow all of these laws that support multiple uses of public lands when managing horses. So wild horses and burros were protected in 1971 by the Wild Free Roaming Horses and Burros Act. That's before people were coming up with catchy acronyms, so it's always a mouthful. It prevents people from going out and removing them or harassing them, which is what was happening before this law was passed. So people were just like rounding them up and selling them to slaughter, rounding them up and using them for things or whatever. It was just a free-for-all. And then it gives authority for BLM and Forest Service to manage them at appropriate levels. And I do want to note that wild horses and burros are protected from sale to slaughter, what BLM calls sale without limitation. But this is only through an appropriations provision that has to be included every single year in the Interior Appropriations Bill. So it's not actually in this base authorizing bill that was passed in the 70s. And this is really important to note because that means that every year it can be removed, right? And we've seen this happen, and I'll talk about that in a minute. So there's also other agency instituted measures that are designed to prevent horses from going to slaughter. One of them is different instruction memorandums that the agency issues that restrict the number of horses that someone can buy at any one time. So they can't like back a trailer up and take 70 horses out because that's pretty sus, or how many you can take over a certain time period. So there's a limitation on like, I can't remember what it is right now, but it's like 6 horses in 6 months or 10 horses in 6 months or something. There are also provisions that can increase the risk of horses going to slaughter. One of them is the Burns rider, which is a lawmaker who slipped a provision in that allows horses that have been put up for adoption, which is a much more like protective way of getting them out of government hands, 3 times or more to be sold, but that's still with limitations. So in theory, like people are signing a contract saying that they're not going to sell them to slaughter. There's also a program called the Adoption Incentive Program, which is designed to save the government money. Essentially, it pays people $1,000 to take a wild horse or a burro, but the burros are very popular, so they don't have trouble adopting them out. And it's pretty easy to see how this would set up kind of weird incentives. It is a lot cheaper for the government to do this because over the course of a horse's lifetime, they're paying probably $40,000 to keep that horse off range, and that might be higher now because this is a few years ago. But it does set up weird incentives for people to want to take that $1,000, and who knows what happens to the horse. In theory, there's compliance checks and things like that, but it's sort of questionable how often that happens and how consistent their review is. Okay, so now that we're all experts on the wild horse issue, and you have a good understanding of like the political context, I want to think through the different strategies that are happening in the real world and sort of what you would choose if you were tackling a problem like this. Is it what is needed? What is the issue? Is it federal legislation that goes through a super partisan natural resources committee and can't pass through budget reconciliation? We can talk about that afterwards. Is it an appropriation strategy that can fluctuate from year to year and you can't legislate, so you can't like create new programs or like do anything new? You can just fund and not fund things. Should we pursue regulations that can come and go with administrations, or should we look to on the ground management and working with like local folks that are managing horses and trying to move them in small incremental directions? This isn't really lobbying, but like it is part of like a general legislative strategy. So these are just all tools in the toolbox and all have advantages and disadvantages, but we have to revisit those questions that we were thinking about earlier, which is like, what are we trying to fix? Do we want to be pragmatic or ambitious? Is there an engaged constituency on this issue? That is very, very true. Are organized stakeholders interested and willing to engage and partner? This changed a few years ago, and now that is the case. Sorry. My iPad just had a seizure, so that's fun. And then what is the timeline, and then how do all of these things relate to one another? So here's what's happening in the real world. These are 4 authorizing bills that have been introduced on this issue pretty recently. The first bill is a ban on helicopter gathers. So we talked about earlier that helicopter gathers can be super stressful for horses. They can be really dangerous. The BLM does have a comprehensive animal welfare program that they're supposed to follow, and that the helicopter pilots are supposed to be following when they chase the horses. Like they have to stay back a certain number of yards and things like that. But the reality is that like chasing horses through the landscape with like a big loud bird is gonna cause some issues. However, there are trade-offs to this, right? Like if you can't use helicopters to gather horses, there's really no other way to do it. So that means that it's really hard to implement fertility control. It's gonna be really hard to do emergency gathers if something is going wrong on the range. So these are trade-offs. I don't think that this bill has been introduced on the Senate side. The second bill is designed to ban the slaughter of wild horses and burros. This is a small tweak that's sort of solving the problem of like future uncertainty, because we know right now there is an appropriations provision that prevents that, but it could happen at any time. So this is an example of like maybe a small, more supportable tweak bill that's out there. The third bill is designed to support the use of fertility control, like generally, and also to train veterans to implement it, which is pretty cool. It may be less controversial and can fly under the radar, but again, there's no big picture thinking here. Like we're not like considering like the broader fiscal concerns or big picture management strategies or the horses that are being held off range. So smaller, but also like an interesting concept. And then the last bill, and I don't think that this has been reintroduced, but the chair of the then chair of the Natural Resources Committee introduced a pretty comprehensive overarching bill that would do a lot of different changes to the underlying Wild Free Roaming Horses and Burros Act. It would require the use of fertility control. It would get rid of the adoption incentive program where they're paying people $1,000 to take horses. It would prohibit the sale to slaughter and a lot of other things. But this would be pretty difficult to move through since it is such like a comprehensive bill, and there's a lot of like things that would make members like throw flags on the field. Okay, I apologize for this slide in advance. But I think it's important to look at the language and to like consider both House and Senate. So it's an eyesore. But one side is the Republican-held House. The other side is the Senate, the Democratic-held Senate. And I just want to note that like these two reports are almost identical. So this is showing of like bipartisan support for a management plan for wild horses and burros that like is quite revolutionary because just a few years ago, the House actually removed the protection against slaughter. I think this was 2017, so FY 2018 is when they did this. And the Senate held the line, like they did not follow suit, but the Senate was also in Republican hands. Typically, they're simpatico on what they want to see in various bills. So we were super concerned at this point. The Senate ended up holding the line, but they turned to advocates and said, hey, like, something has to change. Like we cannot continue down this path that we're on right now. Like there's too much gridlock. Everyone is pushing in different directions. And I can talk a little bit more about this in questions because it's kind of a long story, but it lit a fire under a few humane groups, a few animal protection groups. And we came up with a management proposal for BLM and eventually got the support of a bunch of interests that had been fighting to essentially kill horses for many, many years. Like Farm Bureau, National Cattlemen's Beef Association, Utah Governor's Office, county commissioners, and so on. And there was a one particular representative who was sort of leading the charge on this roundtable and trying to get folks all on the same page about what needed to happen. So since that happened a few years ago, language like this has been introduced or has been included in annual appropriations reports, and funding for the program has nearly doubled. So when we started, it was at 80 million, now it's at 143 million. And there are some very clear like welfare provisions in here, animal protections provisions in here, with some other concerns that appropriators had been talking to us about. So the last strategy that I wanted to highlight that I think is really interesting and innovative is state involvement. So wild horse and burro management is very squarely a federal issue, but governors and other state agencies can be super influential in putting pressure on federal agencies as well as creating new funding streams for things that the federal government may not have authority to do. As you can imagine, Governor Paulus has been fantastic on this issue, as has the first gentleman. They've been super engaged, and they convened a series of stakeholder roundtables in the state. So with folks that are active in the state, working with horses in the state, actively lobbying in the state legislature. And one of the like innovative ideas that came out is this new law, which sets up another funding stream for wild horse and burro management. And this stakeholder group is ongoing, and they meet consistently and talk about how to increase the use of fertility control and support the federal agencies that are working in the space that might feel resource strapped. So with that, there's no perfect answer to any of these issues, right? Policymaking is hard and it always comes with trade-offs. So there's no real like moral to this story. I think all different strategies are acceptable, but the point is that you have to think through the strategy before you go down this path and think about it hard and how this is going to meet your goals for protecting animals in the short and long term. So thank you for your attention. I'll get off my soapbox.
Thank you, Eric and Katie, for those really wonderful presentations. We now have time for audience questions. If you have a question, please line up behind one of the two mics at the front of the room. Virtual attendees, know that you can submit questions via the Q&A icon at the bottom of your screen. So we'll go ahead and start here.
Hi, my name is Jennifer. This question is for Eric. I live in Washington State, so I've been following the macaw whale killing request quite closely, and it's been enormously frustrating. I've written letters to NOAA. I have twice attempted to attend county hearings that were canceled without notice and never rescheduled. So as you say, it seems like the federal government is certainly not very concerned about this. And we have a very progressive governor who is usually very good about animal welfare things because we have the ban on octopus farming. So what is the role of the state? Because he's been very quiet on this and he seems to not be doing anything about it while they've killed at least one whale and I think have either killed a second or have been given permission to kill a second. So is there a role for the state of Washington?
I think legally, probably not,
Ah.
unfortunately. So the authorization, because it's a tribe, and I think one of the problems, just sort of to step back from that, especially difficult issue, is that the federal government, and this has been true about both administrations, have kind of seen their role as protecting what they regard as tribal interests. The federal government is in a trust relationship with tribes.
Right.
And so in varying degrees, I think that's how they've kind of carved out their role. But at the end of the day, this is both has an international component and a federal component. The international component is that any whaling, at least by signatories to the International Whaling Convention, which is the international agreement that oversees all of this, all those signatories have to ultimately get approval from the International Whaling Commission. And so the federal government has to decide if and when it's going to go to the International Whaling Commission and ask for a quota to be set under that international convention. And that's kind of the way the system, is set up. And that sort of historically has happened, for example, when Alaskan tribes engage, in hunting, but other countries that are signatories have done so as well, the Russian Federation, and others. So it really is ultimately a federal responsibility to decide. So they're the ones that can decide whether to promote the tribe's interest in whaling or to basically decline to do that. And that actually, one issue I didn't get into is that there's the NEPA component I focused on. Due to time limitations, I left out the Marine Mammal Protection Act component, which is the other statute that comes into play. And another ruling that we had gotten was that the federal government had to comply with the MMPA, which basically says you can't kill any marine mammal under most circumstances. And ultimately, they said you had to get a special exception from the MMPA to go forward. And that's what's going on now. They ultimately decided, after going through a long process, an administrative law judge, that they were going to pursue and grant this exception, which would then allow them to go to the International Whaling Commission. So that's kind of a long-winded way of saying that legally, I don't think the state has much, if any, role to play. What I can say is that I think the state could certainly play an important political role. And I think for the most part, for what I've seen, and I have to say, I followed this issue much more closely when at our firm when we were litigating it. It's actually the litigation part has been taken over, and Animal Welfare Institute has been the major animal protection group, which has basically been pursuing this for years, now represented by Eubanks law firm with a great lawyer named Lizzie Lewis, who's doing a lot of that litigation. But I think my sense is the state, and I think this has probably been true about all state government officials, and they're in a difficult position. I mean, there's obviously very vocal opposition to the hunt. But on the other hand, there's as I was saying, this has been a difficult issue in the sense that, frequently, many of us, and I'm sure the state officials feel this way, they don't want to be on the other side of tribal interests. And it's a sad situation. I mean, like most tribes, the Makah tribe has suffered horribly under, what we all know was mistreatment of tribes. And there's also no doubt that whaling back in the day was an important element of their community and their cultural interests. So I think, without knowing exactly where this particular situation is at the present, I think it's probably a difficult one. And I wouldn't be surprised if that's a federal issue. We'll let that work out on the federal level. They got the NEPA process. They've got this other stuff. We're just going to sit back and let that happen. But that's not to say there should not be opportunities for concerned citizens to come in and try to, basically let their voices be heard and say, look, this is happening where we live, and it's going to affect our community very directly. To have the first whaling ever, and you're right, one whale was killed before we could get the whole thing stopped. And it's basically the first whaling that would occur off the coast, the contiguous US in more than 100 years. So incredibly controversial. So I think it's a political matter of organizing and people getting re-engaged. I think some people felt who were interested before that issue has gone by the wayside. It's been on the back burner, but unfortunately, these things frequently come back when you think they're not going to. So I think opportunities for engagement, I would suggest contacting the Animal Welfare Institute, which is the national group, has been spearheading this. There was a great activist named Will Anderson. I don't know if he's still involved, but he was, and he was the name of the case that we did the second time around. You could also contact Lizzie Lewis with Eubanks and Associates, and we could give you the contact information because she's the one she did the ALJ hearing. So they would know what the best opportunities are for, I think, getting involved in applying pressure now.
Thank you.
Sure.
Thank you. And I believe we have a question from a virtual audience.
One is for Katie. My question relates to something that you said in the beginning about difficulties in getting legislation passed in Congress. You mentioned having an issue on the party's platform might make it easier to get legislation passed. Do you know of any examples where a political party had an animal issue on their party's platform? And do you think that it is a good strategy to get a bill passed when the party in power has animal-friendly people at the helm?
I mean, I think if you can get a bill passed, then that's great at any rate. I do think that there are some risks to associating too closely with one party over another or too consistently, because you can, like we were talking about before, it makes things very susceptible to backsliding when that party is not in power anymore, and the issue becomes polarized. So like sometimes even making something an issue, like quote, an issue, is a problem. Like a lot of times these things are common sense. And when I've worked at the state level on things that are super, super polarizing at the federal level because they've been around for a long time, I go talk to state lawmakers, like some folks in like rural districts in Kentucky, and I'm like, hey, like, do you support horse slaughter? And they're like, no, why would I support horse slaughter? Like, that's no. And like at the conference I was at, like they voted with us. And so a lot of times like these things can become entrenched just because of that pull. I do think that there are some issues that that like have gotten more aligned maybe with one policy platform, like farm animal issues, I think naturally fit into like environmental issues. And so the pull is much stronger towards like the Democratic side. And I think that there are risks and rewards to doing that. And there are some things that can make progress, but like generally speaking, authorizing bills are just really, really tough to get passed regardless because of the Senate backstop, right? Like getting 60 votes on anything is just really, really hard. So one of the things that I was talking about before and how a lot of stuff has been passed recently, like the Inflation Reduction Act, for example, is through budget reconciliation, which does not require 60 votes in the Senate. So that has to be a budget measure, like it has to be attached to like a funding mechanism, but that stuff can be super, super powerful. Like we're seeing an entire industry change because of the IRA. So thinking through those like innovative strategies to try to work around the system is helpful. But I think, yeah, I mean, it's a strategy call. So thanks for the question.
Thank you.
Also for Katie, could you speak to the strategy for including two similarly treated but different animals in the bills and whether there are drawbacks?
Like wild horses and burros?
Yeah, I mean, you mentioned like burros are more easily adopted because they're more popular. So when you lump them together, does that affect anything negatively ever?
That's a good question. I mean, they are very different species and they behave very differently. Like gathering them is very different. Treating them with fertility control is also different. They were both included in the base like authorizing bedrock law that protects like wild equids on federal lands. So I think for that reason, they're managed similarly. But in a lot of places, like, as you can imagine, there's like 177 HMAs spread across these federal lands, and all of them look very, very different. Like they're in Nevada, they're in Oregon, they're in New Mexico, like they're all gonna look very different. And burros and horses overlap a little bit, but not always. So I think it's a fair point, but we would probably have to like address it via authorizing legislation to get anything changed.
Thank you.
Yeah.
Hi there, my name is Erin and I'm 3L at the University of Idaho. I'm not entirely sure how familiar you are with some of the things that have been going on in Idaho with regards to wolves. We had a bill pass a few years ago that lifted a lot of the restrictions on killing wolves. So people can snare newborn pups in their dens now. There's a bunch of things that they can do. And I think that 2 petitions were introduced to get them relisted to the ESA. They both failed. And we had a small victory about the incidental trapping of grizzlies. So like some of the time and the place for where wolves can be snared has been limited, but other than that, it's been kind of a big fail. So I was just wondering if you could speak generally to how the current status of wolves in the United States is. And like as a law student, I feel pretty powerless in a state that's full of farmers and hunters. So just any suggestions for how to go from there?
Great question. It's actually one that overlaps both the litigation world and the legislative world, because as you know, one of the reasons why wolves in Idaho are not currently protected is because of a legislative rider that basically at that time eliminated Endangered Species Act protection in Idaho and Wyoming at that point. And so there's a petition, as you mentioned, there were 2 petitions, both of which were denied to get wolves in that neck of the woods relisted. And that was subject of lawsuit currently going on right now. I think there are 2 companion cases, one brought by the Center for Biological Diversity. A great lawyer named Colette Atkins at the center is pursuing that. So if you want much more information than I can provide, she would be the person to go to. Colette, I can give you her information. And that's pending right now. I think it's pending in the District of Montana, I believe is where the case was filed. And it's basically challenging, and it gets into some if you followed the wolf issue, you know that the way in which they've historically approached ESA protection for wolves is unbelievably complicated. Figuring out exactly, so the ESA, just not to get too off on a tangent, covers species, subspecies, population segments. And over the course of time, the Fish and Wildlife Service has been incredibly, it's been very difficult for them to figure out exactly what the population of wolves that they're even considering for listing. So right now, the issues that are pending are whether they properly delineated what the population segments were that should be covered under the Endangered Species Act. And it covers things like whether or not they should have excluded Colorado, which they did in deciding what there was a significant part of the population. So it's some very complicated issues, but I think ones that we have some pretty good arguments on, and ultimately challenge the refusal to relist, because as you say, and I think this was touched on yesterday, state management of wolves has been a horror show. And everybody knew that was going to happen. And the way it ultimately stemmed from the determination by the Fish and Wildlife Service was to apply this incredibly narrow analysis and vision and say, as long as we reach X number of wolves, we'll deem them to be recovered, and that will be enough. And people say, A, that's scientifically invalid, and B, it's going to result in just a horrible treatment of wolves by the very states that basically tried to annihilate wolves in the first place. And sure enough, as you well know, that's exactly what's happening. And I have to say, administrations of all political stripes have been terrible on this issue. It's not like this is one that goes back and forth based upon which administration is in power. So legally, that's the only way it can happen. There's been a lot of success in the courts over the years of trying to cut back on taking wolves off the list at various times. And so this is a case to follow if you're interested in this. And as I say, I think there's a complaint's been filed. I think summary judgment briefing is going to begin. Colette would be the best person, and she's great about, providing input to law students and such. So she'd be the perfect person to contact. That's what I suggest, and happy to give you her contact information to follow up on that.
That would be great. Yeah,
Sure.
thank you.
So this question is for Katie. At the end of your talk, you spoke to some growing bipartisan support that brings in numerous sort of stakeholders in this roundtable, and you spoke to some prospective sort of animal welfare and protection provisions, and I'm wondering if you could sort of speak to those.
Yeah, within the appropriations language. Yeah, I think, so everyone knows that report language is not binding, right? So this is a report that accompanies the appropriations bill. So no one can sue the agency for not doing this, but Congress is supposed to be telling the agency how they want this funding that they're giving the agency managed. And so within that appropriations report, they have adherence to the comprehensive animal welfare program. They have directives to use fertility control, which this is super, super revolutionary. I think it's hard to remember where we were at in 2017 and 2018 on this issue. But Congress was ready to remove protections for wild horses. They were there. And in other countries, that is the case. That's how horses are managed, is through lethal means. And we don't need to go there. The way out is through fertility control. So those two provisions are in there. And then they also talk a little bit about public-private partnerships and looking for funding in different ways to continue supporting the program. It's not directly animal welfare related, but I think that it does have good indicators that they want to continue the program and let it balloon and continue to grow and continue to work with stakeholders. This issue traditionally has been hyper, not even partisan, but just super, super divided. And recently there has been a lot of commitment from a variety of stakeholders. And I don't know if this is a super replicable model, because there was a crisis moment. And I think that that crisis moment is really, really important to get people at the table. And it was also facilitated by some lawmakers that were you all need to get your act together. And everyone, not just us, or everyone's going to be unhappy with what they do. So part of it is congressional leadership. And then part of it is this crisis moment that everyone felt that allowed this partnership to, or maybe not partnership, but stakeholder group to come out of it. But we'll see what happens after, new administrations come in and out. I think this has been maybe 4 or 5 years going at this point, and things could always change. But right now they're continuing to include that language and continuing to include the protections. And I think a lot of that is because they've stayed together.
And this question is for Eric. You mentioned in your talk that Chief Justice Roberts, in authoring the NRDC versus Winters case, affirmed sort of the import of NEPA and following those steps, and that it doesn't necessarily require sort of the right outcome. And you also mentioned that, Congress, recently amended NEPA in a way that seems to support sort of your reading of the statute. And so can we glean from these and sort of other developments some hope for this case?
I guess there's always hope. It springs eternal, as they say. And sometimes the court will surprise you. I mean, the Prop 13 case, I'm sorry, 12, thank you, came out a way many of us were happy with, of course. The Supreme Court's recent track record on these kinds of cases isn't generally not cause for optimism. People may know about a Clean Water case called Sackett, where the court drastically curtailed protection for wetlands. Know about, of course, the West Virginia case, where the court really cut back on the ability to regulate greenhouse gases. And of course, huge administrative law case, which was, I think, mentioned yesterday, Loper Bright, which overturned Chevron deference. All of which is to say, given the composition of the court, it's hard to be optimistic. We think that, however, as I kind of mentioned, the petitioner's position is sort of so much all over the place and really hard to pin down that we're somewhat hopeful that members of the court who might not otherwise care much about wildlife and environmental protection will be at least somewhat concerned about the inability of the petitioners to even figure out a consistent, coherent position to take. But it remains to, we just don't know. I mean, all we can do in a situation like this is make the best arguments we can and then be prepared for the argument and see what happens. Yeah, I mean, we never give up hope. We make the best arguments. We're in an era of an extremely conservative, I don't even want to call it that, but right-wing Supreme Court. That's no surprise. So we want to keep cases out of the Supreme Court. This one we weren't able to, and we'll make the best arguments we can and just hope for the best. So yes, we still have hope, at least until the decision comes out. Then we'll see what we get.
Thank you. So we have arrived at time.